So that's a little bit about our organization. We were originally the COVID-19 eviction defense project that was started right when a lot of the shutdowns were happening, when everyone was really concerned that there'd be this huge wave of evictions. And thanks to several programs and efforts, that we haven't seen that huge wave of evictions that was anticipated at the time. And so now, sort of coming out of the pandemic, we're moving on to a little bit more in terms of broader economic justice. So today I have sort of two parts of my presentation. The first is the eviction process, and the second is diving into source of income discrimination. And just to give you sort of a broad overview, the eviction process has sort of 5 phases to it. There's the demand, which is the notice that goes out to a tenant that something has gone wrong and they either need to fix what's gone wrong or vacate the property. The second is the filing of a complaint. This is when the landlord actually begins the eviction process, files a complaint with the court. The return on summons date, which is when the landlord or when the tenant has to file an answer that responds to the complaint filed by the landlord, or appear in person, but really they have to file the answer. That's the key to that stage. The fourth stage is when there's a hearing, and this gives both parties an opportunity to present their evidence and the judge to make a ruling. And then if that does not go in the tenant's favor, the final stage is a writ of restitution, which is actually what gives the sheriff the right to restore property, to restore the premises, possession of the premises to the landowner or the landlord, as opposed to the tenant. So eviction process is a little bit different than most laws. So it's a expeditious remedy, which means that a lot of times civil lawsuits take 1 to 3 years to complete. An eviction process is very fast. It usually takes less than a month, and they're designed to move quickly. And for a non-payment of rent case, this is somewhere between 25 and 23 days, depending on how long certain factors take, and that's from when the demand is filed until the sheriff restores possession back to the landlord. So this is happening really quickly, raises some due process violations, court processes that it still requires that people have the opportunity to be heard, to raise their defenses, and it's balancing that with sort of the imminent harm of if it took a year or two to evict someone, landlords would very likely not rent properties all that often, and it would be it would not function as sort of a staple of our community and society. So because of that, because the quick pace of evictions, the law says that the landlords have to have very strict adherence to the statutes and to the process that is laid out. And so landlord-tenant law is a lot of going over the same statute and the same words and discerning every drop of meaning from them, because of this sort of fast pace and the concerns about due process that it raises. So the first stage is the demand for notice, or the demand or notice to quit. This is the first stage of the eviction process. There are 11 different circumstances that can trigger an eviction. We call these unlawful detainers. So this would be which really is, from a sort of legal perspective, we're saying that the tenant has unlawfully possessed property that belongs to another person outside their rental agreement. And so there's sort of 11 circumstances that can trigger that. They're spelled out specifically in the statutes, which I have the 13 4104. Oh, sorry. And if the eviction is based on a notice to quit, then there isn't necessarily any reason that has to be given to in the tenancy. Those 11 circumstances, there are a lot of holding over after a lease is expired and doing X, Y, or Z. And I'm happy to go over those if that's really helpful. A notice to quit is basically saying that the tenant no longer has a right to possess the property, and it's not based on anything the tenant did or didn't do. Oftentimes these are people who are paid up on rent, and everything's going well, and the landlord wants to rent to someone else, like a family member, wants to move in themselves, wants to do extensive renovation, wants to sell the property, wants to do whatever. And there's a recent Colorado court case that said for a notice to quit, these can be brought for any reason or no reason at all, whether it's good, bad, or discriminatory. So there's some case law out there that says, for example, a notice to quit that was brought on the basis of a tenant refusing to engage in sexual relations with her landlord, that under current Colorado law, that was a permissible reason to give her a notice to quit, and that under current Colorado law, there's no that a discriminatory reason is fine because it doesn't require a reason. So that's probably not the intention of most law. So and that hearing or that ruling is being challenged, but that sort of just gives the broad reasons why people can end a lease or end a tenancy. And the most common evictions are filed for non-payment of rent is number one, followed by a substantial lease violation or repeated lease violations. The statute also spells out what a substantial lease violation is. It's not sort of reading through the technicalities of a lease and being like, oh, you didn't move your trash cans on Monday, you moved them on Tuesday, you're in violation, we're done. That would not be covered as a substantial lease violation. It would be something usually resulting in something with criminal activity or other sort of something that disturbs the peace, the well-being of other tenants, something that disturbs the community and results in something pretty unsafe. The other repeated lease violations, this is another sort of area where it's not completely settled what that means. So there's case law that says a tenant who had a small, not substantial, but had a lease violation, and then 3 weeks later committed the same violation, that was actually two separate violations. It wasn't an ongoing repeated pattern of the same violation. And I believe in that case, the violation was refusing to let the landlord into the apartment to fix something. So this is also county court. County courts can sometimes have very different interpretations of what the law says, and judges interpret different statutes. Oftentimes these cases are not appealed, and there's not a lot of case law that, especially recent case law, most of the case law is from like the 1980s and 90s. And so sometimes it's hard to have a standardized interpretation of what all of these different provisions mean. But to the best of, but to the legislator's credit, they did spell out substantial violations pretty clearly and circumstances that could trigger an eviction. Like I said, non-payment of rent cases are the most common, and usually they require a 10-day notice unless the property is covered by the CARES Act. Then it requires a 30-day notice. There's also a legal battle over whether this provision of the CARES Act is still in effect or not. And I believe the Supreme Court intends to issue a ruling on that, the Supreme Court of Colorado. And so at the moment, it may or may not be covered by, it may or may not be good law moving forward, but for the time being, if the property is covered by the CARES Act, then there's a 30-day notice requirement, which this is really pretty substantial for eviction cases, and specifically for non-payment of rent cases, because non-payment of rent cases, if a tenant is able to come up with the money, then the case has to be dismissed. And so having an extra 20 days to come up with that money is really important for a lot of tenants. A substantial lease violation generally only requires a 3-day notice. And so in those situations, like I said before, it usually involves police contact, something criminal, something incredibly disruptive that's posing a harm to the community. And so that 3-day notice is to compensate, is to sort of make up for potential violations, and potentially unlivable conditions for other tenants. And then for notices to quit, these are the notices that end a lease without offering a reason or a justification. These notices are based on the length of the lease. So for a month-to-month lease, this requires 21 days notice. For a year-to-year lease, which is a little bit odd, it would require 91 days notice. If it's less than a week, this would also cover some like short-term rentals. I believe it's 3 days, but all of those timelines are spelled out in CRS 1340-107 if you're interested in all the different timeframes. Employer provided housing is also sort of an odd duck in this world. Employer provided housing does not necessarily require a court process. So this was a law that was generated out of a situation in which a person who lived on site at a nursing home or an elder care facility was allegedly abusing the tenants of the facility, and they still had to go through the traditional eviction process, which was endangering the tenants. And so the legislator in response passed this law that says it's actually in the Colorado Wage Act as opposed to the housing tenant landlord tenant laws, but that if it's employer provided housing and there's a risk of some sort of danger, if the employment ends, then the employee is given 3 days of notice to vacate. And as long as it's listed as a license to occupy as opposed to a lease, and there's some certain requirements to fall under that, then the employer would not have to go through the full court process, but just have the 3-day notice and then go to the sheriff directly and schedule the sheriff to move out the tenant in an expedited process. There's it's hard to track to see how many of these are happening, if they're happening that way, because a lot of times employer provided housing, if it's not going through a court process, it's hard to get data on what's happening. And then for a demand or a notice to quit to be valid, it must be in writing. It must specify the grounds alleged for the right to possession. So for a notice to quit, this just says, under the statute, I'm issuing you a notice to quit. Your lease ends on such and such a date. It doesn't have to give more information than that. If it's one of the other 11 circumstances that can trigger an eviction, it has to list that out specifically. It has to describe the property, state the time when the property must be delivered to the landlord, and be signed by the landlord's agent. And it must be served on the tenant personally or it can be posted on their door. There's supposed to be diligent efforts to serve the tenant personally, which means having a process server hand the demand to the tenant as opposed to just posting. Occasionally that comes up in some cases where someone is not at the property and does not receive the notice, and there's some questions as to whether or not that notice is still valid, or if the notice says, you know, this is a notice to quit, but it's really a substantial lease violation allegation, and it's not really done in accordance to the law. That could be a really good defense to the eviction, and the case law is pretty clear that if the notice does not follow the current law, that it would be it wouldn't, the lawsuit would have to be dismissed, unless the demand and notice meet these requirements. Most times, if a case is dismissed for those reasons, and the conditions still exist, then the landlord would just sort of have to go back to the beginning of the process and reissue the demand or notice. Sometimes it ends the case permanently, but for the most part. The next step of the eviction process is filing the complaint. So this is when the landlord actually starts the lawsuit against the tenant. And the complaint has some specific language that's required by statute. And if it does not have that language, then it is invalid, and that's a defense to the lawsuit. It has to tell the tenant the place, time, and date to file an answer or appear. This takes place 7 to 10 days. There has to be, it's usually 7 to 10 days from when the landlord filed the lawsuit. And so, and it has to describe the property, the violation, the name of the person, the name of the tenant, and ask for the court to recover the property. Those are sort of the critical elements. It may also say that rent accrues at X dollars per day, and that on, you know, and give the tenant an idea of how much money would be owed on the court date or at any given point moving forward. Personal service is required. So this is where the person would, where the process server would actually have to hand the documents to the person, but if diligent efforts to serve the person have not succeeded, then the landlord can post the documents on the door. Usually, well, it says in a conspicuous place, so usually that's front and center on the front door, and then is also required to mail the documents to the tenant. This is to ensure that the tenant gets actual notice of it, to try and make sure that the tenant has actual notice that a lawsuit has been filed, and that they're required to do something to submit an answer to the court on a specific date. And if the service of these documents is served by posting or mailing, then the court can only enter judgment for possession. They can't enter judgment for money or other requested relief unless the documents are personally served on the tenant. That doesn't come up a whole lot, because in a lot of cases, if it is a non-payment of rent case, most people would pay the rent if they had the money, and so the landlord is most likely interested in getting the apartment back so that they can sign a new lease with someone else, and sort of cut their losses, as opposed to necessarily going after the tenant for the money. They can also do that in a separate process if after they get the apartment or property back. The complaint also, there's also a list of required documents that have to be served alongside the complaint. These are things like a list of references and resources for tenants and renters, things like a discovery request form so that the tenant can ask for documents relevant to their case, along with a summons that tells them when they need to be at the court, and some information about about the courtroom and what date and time they're required to file the answer, and the language that's specified by the statute, which in some cases, and then I'm trying to think, there's also they have to have a blank answer form. So there's a JDF, which is a document that's prepared by the judiciary branch that has sort of the elements that that helps a tenant submit an answer and know what the court is looking for. And so all of those documents have to be served, and a request for fees, for a waiver of the filing fees if a tenant does not meet a certain income threshold compared to their expenses. They may be able to file an answer for free. All of those documents and all of the language that's required by the statute have to be served with the complaint, or else the plaintiff will not be able to move forward with the lawsuit, and that would be a defense that could be raised by the tenant at any time before or after if a judgment enters. And just sort of basically the complaint is the starting of the court process. So before that, there isn't, people may be getting a lot more demands than we think they are, because if it doesn't go through to the court process, we may or may not know about the demand being issued. I'll also say the demand for rent or possession, or the notice to quit, if people self-evict, if they leave the home within the time period required by the notice or the demand, then they are considered to have been they wouldn't have an eviction on their record. They would have chosen to vacate instead. So then the third step, and this is a big one for most tenants, is the return on summons date. This is the date that the tenant must file an answer on or before the return on summons date, in which they deny the allegations and raise every defense that they have. This is really important because a lot of times tenants may not know all the sort of technical legal defenses that they have. And if they don't raise them here, they may possibly be barred from raising them later on as it gets closer to the hearing date. There's a process to amend an answer, to change to include more defenses. But this is sort of big for that reason. Tenants must also assert counterclaims that come from the same transaction or occurrence that is the subject matter of the landlord's claim, or risk losing the counter suit forever. This is important because, again, a lot of times tenants may not know that something their landlord is doing is illegal and violates, and that they would have a claim or a counterclaim. And so it's also sort of an unsettled area of law as to what the same transaction or occurrence means exactly. It's sort of a case-by-case basis as to whether or not a tenant waived a defense or a counterclaim. For example, well, in that case, I'm not going to give an example. That's not a good example to give, actually. So this is important. If they don't file an answer by the end of the day, or they file an answer that does not raise their defenses adequately, then a couple things can happen. If they don't file an answer, then the judge can enter a default judgment against the tenant, which just means that they did not appear when they were supposed to appear. They did not file the answer in the way that they were supposed to file an answer. And so the court has issued a judgment for possession against them. That's sort of, that's what gives the landlord a right to actually schedule the sheriff to come and remove the tenant. The this can happen whether or not the tenant has any defenses, and so they may, and sometimes this happens if someone pays their landlord, but their landlord didn't communicate to their attorney quite yet that they were paid on time, and there can be some sort of timing headaches given the short duration of the eviction process. And so that could happen also if a tenant does not file an answer or files an answer that does not assert all of their defenses. The landlord or the landlord's attorney might file a motion for judgment on the pleadings, which then the court would look at what was filed and say, this is a legal defense, this is not a legal defense. I'm ruling in favor of the landlord, and at that point judgment can enter against the tenant without ever having had a hearing where they're able to present evidence. So this return on summons date is pretty critical, and is really the turning point in a lot of cases. There are some grounds on which a tenant can ask the judge to set aside a default judgment, but that gets into a little bit more of the technical legal strategy. And it's sort of like the boulder has started rolling downhill on the eviction at that point, and it's harder to stop it. So that's a critical point on the return on summons date. This is also really important that tenants recognize what this means, that a judgment could enter against them, all of those sort of pieces. It's also important because Colorado has a right to cure statute, which means that tenant in a non-payment of rent case, tenants can pay whatever they owe up until the point at which judgment enters. And so if judgment enters and because they didn't file their answer, they also lose the right to cure after that. So that's the return on summons date. Also when they have to file an answer. The next phase is the hearing. So if the tenant files an answer and the landlord doesn't file for judgment on the pleadings and it gets to the hearing stage, the court will set the eviction hearing, which functions pretty much like any other trial, just sort of in a condensed form usually because of the expedited timetable. So there's likely an opening statement, or there's an opening statement. Each side gets to present witnesses and other evidence. They get to cross-examine opposing witnesses and give a closing argument. The landlord must meet the appropriate burden of proof. And so in some cases, so in some cases that could be that the tenant doesn't have to put on a whole bunch of witnesses and stuff. They just say, you know, they're saying that I did this, and then they provided no proof that I actually did what they said I did. They haven't met their burden of proof, and so I should win on those grounds. Usually it's a little bit more involved than that, but that's the time at which everything has to be asserted. And then generally there's no right to a jury trial. Tenants can request a jury trial, but it would be very rare that a judge would grant that request. Most of these cases are just going before the judge. There's also a fee to request a jury trial that's non-refundable if the judge denies it. And the only landlord-tenant law that I'm aware of that contains a right to a jury trial is discrimination based on immigration status under the Colorado statute. And that's sort of the only law that has that provision that requires that a tenant be granted a right to a jury trial. And it sort of, everyone presents their evidence, everyone gives their statements and their arguments, and then the judge sort of mulls it over in real time. The judge might ask questions, and then generally immediately issues a decision orally. So that would be in a transcript, and people can request and pay for the trial transcript. But generally those opinions aren't published the same way that, say, district court opinions are usually published. So sometimes this makes it more difficult to track trends in how judges are making decisions, because a lot of these cases are, you would have to know exactly what case to go look at the trial and request the trial transcript. There's no sort of database to be able to search and see how certain judges are ruling on certain issues. So if the judge finds in favor of the landlord, then the landlord can ask for a writ of restitution to be issued. And there's a 48-hour waiting period, so the writ of restitution wouldn't be issued for another 48 hours. And that's actually what gives the landlord the right to take possession of the property. The tenant, if they're successful at the hearing, that the judge would likely dismiss the case. A lot of times this happens in non-payment of rent cases. If the tenant can go in and show that they paid money either to the court or to the landlord directly, and that any default has been cured, then they would be able to dismiss the case. They usually dismiss them with prejudice, which means that the landlord doesn't have an opportunity to refile the case. In non-payment cases, they wouldn't have a lot of motivation to. In substantial lease violation cases and other things, it's to prevent the landlord to say, like, oh, but that one time you did this, you did this, you did this. But again, this is county court, and each court functions a little bit differently, all based on these same rules, but judges just tend to have different processes sometimes, as long as they fit within this framework. So then the last phase is the writ of restitution. And the writ of restitution is what allows the landlord to schedule the sheriff to remove the tenant after a 10-day waiting period. Only the county sheriff can restore possession to the landlord. If a landlord or other entity changes the locks the tenant out, turns off the electricity or utilities, breaks windows or doors, or otherwise takes pretty serious efforts to evict or constructively evict the tenant, then they are likely in violation of the law and liable for damages associated with a wrongful eviction. So in Colorado, they don't like self-help. So landlords cannot say, oh, you owe me this money, you didn't pay, I'm going to either lock you out of your house or make your life so miserable that you decide to leave on your own. That would be a separate sort of lawsuit, and in some extreme cases, potentially even grounds for reinstating the property to the tenant. And then this process, sometimes a sheriff will post like a bright pink or bright orange notice on the door of the tenant, telling them that they have 24 hours or that they've been scheduled to carry out an eviction. Different counties function a little bit differently on what the sheriff does. Sometimes the sheriff may give the tenant an idea of when they're coming. Other counties, they don't, based on this, on a sort of a principle of safety and order, that if a tenant knows when the locks are going to be changed, they might do something that, you know, potentially would trash the apartment right before then, so that because they're mad at the landlord, or potentially hole up inside and refuse to give up possession, or, you know, there's a number of different circumstances that I personally have never seen happen and would be very, very rare, but that could happen that people want to avoid. Move outs are only allowed by statute, are only allowed to occur between sunrise and sunset. So no middle of the night throwing people out. Generally, sheriffs do not schedule move outs during major holidays. They generally don't do them on weekends, although they will sometimes. It's not a hard and fast rule. Other states have prohibitions on evicting tenants during when the temperature is below a certain degree, or if there's other certain emergency provisions happening. Colorado doesn't have those protections currently, but that's sort of the landscape there. And then a writ of restitution remains in effect for 49 days after issuance, and then automatically expires under the law. And if it expires, the court can just reissue the writ of restitution. Potentially, if during that time the parties reach an agreement or something to that effect, the reissuance is just to make sure there's not sort of a hanging writ that's out there for years at a time. And it just sort of requires the landlord to check in and be like, everything is still the same that it was before. Can you please enter the writ of restitution or reissue the writ of restitution? So that, in a nutshell, is the eviction process. Like I mentioned earlier, there's a right to cure in Colorado. This is really important because most cases are non-payment of rent cases, and this right to cure requires that a landlord accept payment of all amounts due according to the notice, as well as any rent that remains due under the rental agreement until the judgment for possession issues. And so until there's a judgment against the tenant can make payments. And this comes up a lot where a tenant has rental assistance on the way and they're running to the court to make the payment. And if they're able to do so, this keeps the eviction off their record, allows them to stay stable and housed. It also means that the court is required to vacate any judgments and to dismiss the case with prejudice, and this right cannot be waived in the lease. So it's a pretty strong right that the tenant has. The tenant can also pay the landlord directly or pay into the court, and then give the landlord a notice of deposited funds. This is just the tenant confirming with the landlord that they have made the payment, and the court can look at it and say, yes, you've made the payment and I'm going to dismiss the case. Sometimes landlords also do not want to accept funds at the last minute. They would rather move forward with the eviction, and so being able to pay the court is really important so that they can stay housed in that way. And that is sort of the midpoint in my presentation today. So I'll stop here for a little bit and answer any questions you all have. It does look like there's a couple in the Q&A.
Yeah, there's a couple in there, and then if anybody has a question, feel free to unmute yourself. But so let's see, Kelly, are there any efforts in the legislature this session to overhaul the notice to quit laws? It seems like a massive hole in tenant protection.
Yes, there is a bill in the legislature right now, commonly referred to as the Just Cause Eviction Bill. And just cause evictions would require that a landlord have, there's sort of two categories of cause to trigger an eviction. One would be that it's the tenant's fault, so it's the same substantial lease violation, the substantial lease violation, non-payment, and repeated violations. And then there would be no fault evictions, which would include things like the landlord wanting to renovate the property and then it would expand tenant protections. There would also be sort of an assumption that a month-to-month lease will continue until one of these situations occurs. And so it's sort of, oh gosh, I'm blanking on the numbers right now, but it is, the bill passed out of the House committee and I believe is moving on to the Senate. So if you look up just cause evictions, you can read the text of the bill and kind of go through that. And this does come up. It's not as common, but for example, a tenant who might be on a fixed income, rented her apartment for over 10 years, and then gets 21 days to have to find a new place to go. Stuff like that does happen, and it's really destabilizing, not just to the tenants, but sort of to the community that's based around long-term tenants who end up on month-to-month lease. A lot of times people don't realize that they've sort of slid into month-to-month leases as well. It can be like triggered if a tenant doesn't give a certain amount of notice that they want to renew the lease, they automatically become month-to-month tenants. And so that happens to a lot of folks who might think that they're actually on a year-long lease. Oh, okay. And then another question, in order to not have an eviction on the record, a tenant must self-evict before which step in the process? So this question has several different, depending on the conditions around the eviction process. Generally, if they evict before the lawsuit is filed, they would not have, if they self-evict within the terms of the demand. So if they have a 10-day notice for rent or possession of the property, which is what, like if they're behind on rent, that's usually what it says at the top. If they leave the property within the 10 days, even if they're not able to pay the rent, then the landlord can't file a lawsuit for possession of the property because it's already been turned over. And so at that point, there would be no court filing, and so then there would be no like mark on the record. The landlord could still potentially come after the tenant and say, you owe me X amount of money in rent, and ask for the money, and they might get a money judgment against them, but they wouldn't have the eviction, which is sort of the biggest piece when looking for new housing and going through that. So we have had experiences of hearing about evictions after the fact. Is there a public website we can access to see if a writ has been issued? Sort of yes and no. You'd have to go through the court filings, which generally attorneys can look at them. You also have to get permission. If the case is suppressed, then people are not allowed to look at it at the case unless they have explicit permission from the tenant to do that. And so they wouldn't be able to see the restitution until usually at the point that a judgment enters against the tenant. That's when the case becomes unsuppressed. So if you have access to look through all the court filings and you know the person's case number, you could potentially look up and see if there is a restitution filed against that in that case, as long as the case is unsuppressed. So that's not a super helpful answer. Generally, it's pretty difficult unless you have an attorney who has access to the Colorado e-filing system and you have explicit permission from the tenant to look at their case. I'm assuming housing choice, HCV is housing choice voucher tenant. Correct me if I'm wrong on that. If the landlord is not accepting rent and a tenant pays the rent to the court, what happens if the landlord sends back the HAP payments to, okay, so this would be a pretty technical. This would be a very technical issue if it came up. So if the tenant pays rent to the court and gives the court a notice of deposited funds, the landlord is supposed to act as if they've received payment. And so they shouldn't send back the HAP payments to DOH. Things don't always happen the way that they should. And so my guess would be that if the landlord sends back the payments, then the tenant, then the court would end up ruling on the case and moving forward, and very likely the HAP payments would have to be reissued, I would guess. I can't think of a specific time when this has happened to remember how it's gone down. So whoever sent this in, I don't want to tell you the wrong thing off the top of my head. So I will, if you want me to, I can follow up with a better answer. The sort of, if everything happens the way it's supposed to, the landlord is supposed to get the notice that the funds have been deposited with the court and move forward as if the payment has been made, and so then they wouldn't return the HAP payments. But if that doesn't go that way, I would have to do a little bit more research to see what the process would be exactly.
Hi, Kelly, it's Catherine.
Hi.
What would you suggest? Because we, the Division of Housing, we pay that housing assistance payment to the landlords, and oftentimes, not often, but sometimes we do get, they refuse it. They don't deposit it. They send it back and say, we're evicting this tenant. We can't accept payment. Otherwise, that means we can't evict. And so I guess would the suggestion be, if the tenant pays the court, but the landlord doesn't accept the HAP, do we just like have that tenant reach out to Colorado Legal Services? Or because we of course can't provide them with that legal advice, but it does happen where the landlord believes that if they deposit our money, they're agreeing to continue to rent to the tenant.
Yes, and so this is a little bit of a area where there's a lot of confusion usually. So a tenant can't be evicted if they pay their part of the rent for non-payment of rent, and if the HAP payments get delayed. So in the eyes of the law, those payments are treated separately. And so yes, absolutely, you can send them to us, you can send them to Colorado Legal Services, and just say, and we could help on a case-by-case basis. And there is case law on what's called waiver. So sometimes if a landlord has reached a point where they no longer have to accept payment, and then they accept payment, they're continuing the tenancy, and basically it does sort of stop the eviction process. So if the funds are deposited with the court and the landlord sends the funds back, and the tenant can show that the case was dismissed and now the landlord is back into a position where they have to accept the funds, then reissuing the funds, the landlord should have to accept those. And the landlord couldn't then evict based on not receiving the HAP payments if they're receiving the tenant portion and they've accepted the tenant portion, which is really sort of the critical piece. But some landlords will say, I don't want to accept any payment, because then that could potentially be seen as a waiver of my right to proceed with the eviction. So generally it's sort of a wait and see what happens with the eviction case. And if the eviction case is settled and stopped and dismissed, then the landlord no longer has a reason to not accept the funds, and if the funds are reissued, they will accept them. Or that would be a legal issue that would, that CLS or CED law or any of the other folks could provide. As a result of these new laws, do we foresee more redlining and rental requirements such as higher rent, larger deposits, etc.? That's sort of up in the air, and it depends on which, honestly, it depends on sort of which law you're talking about as applied to what community. My guess would be that higher rent, larger deposit amounts, it's for a lot of landlords, I'm guessing this is about the just cause bill. If that law were to go through, for most landlords, it doesn't change anything, because there's a statement of everyone doing business is required to be working with fair dealings and good faith. So for the most part, the people are still gonna, it wouldn't change the reasons all that much why people could bring evictions, especially considering the two, and when I say vastly the majority are non-payment of rent and substantial lease violations, those still would be proper eviction grounds. And really the only significant change is that a landlord has to put on paper why they're evicting someone under the notice to quit. That's sort of the big change. And that stems from a lot of times that's how landlords who are intent on discriminating on an unpermissible category, that's sort of how they've skirted those rules. But for the vast majority of landlords, it won't change all that much in how they do business. I think the part where it gets a little bit more sticky is the no fault eviction criteria, and if they're required to provide longer notice and other resources. I think there's some language about relocation allowances and things like relocation payments and things like that. It would give tenants more like 3 months to vacate if what's causing the end of the lease is that the landlord wants to renovate the property or sell the property. So it gives tenants a little bit more time. That could result for some people in larger deposits, higher rents. Those are also trends we're already seeing, and so it's sort of for the most part, I don't know that it will change landlord practices all that much, but it could, and it could be in association with the fact that rent is continuing to go up and we're seeing more deposits and larger amounts generally, currently not under the new law. So it's sort of, I think that's where we're at. Other states that have had similar laws have seen increases in rent for some markets, but that's also sort of the trend in general. So it's hard to draw a straight line that these bills would cause rent increases that are outside the rent increase we're already seeing. And if there are no other questions, I'll go on to the next, the source of income discrimination part. So then, here we go. So there's two provisions of source of income discrimination. There's the Colorado Source of Income Discrimination Act, and there's a Denver ordinance as well. And so for source of income discrimination, if a landlord has 4 or more units of housing for rent or lease, it's an unlawful and unfair housing practice to discriminate based on source of income. So this means a lot of mom and pop landlords are able to discriminate on source of income, unless otherwise prohibited by, say, the federal law and prohibition on certain forms of discrimination based on source of income. Source of income is defined as any lawful and verifiable source of money paid directly, indirectly on behalf of a person, including income derived from any lawful profession or occupation, and any income or rental payments derived from any government or private assistance grant or loan program. So there's the two main pieces of source of income are that it's legal and that it's verifiable. And nothing in this law prevents a landlord from requiring proof of income. It just means that they would have to include a housing voucher as a source of income for the purposes of evaluating a minimum income requirement to rent a property. And there's not any case law in Colorado yet on source of income discrimination. This law went into effect in 2021. And so in January of 2021. And so I've looked at some of the other states that have similar laws. There's a really clear distinction between source of income and amount of income discrimination, that landlords are able to refuse to rent to people who don't have a certain threshold, a certain amount of income, but that they can't parse out where that income comes from as long as it's legal, and use that to discriminate. The forms of discrimination that are prohibited, the landlords would not be allowed to refuse to rent or lease, refuse to show the housing to people based on this source of income, refuse to receive and transmit any bona fide offer to rent or lease, or otherwise make unavailable or deny, withhold from another person any housing for rent or lease because of a person's source of income, which is really pretty broad language. And without case law in Colorado, we don't know exactly how far that extends. But the idea is that they wouldn't be able to just say, you can't, you've accepted rental assistance, you have a housing voucher, you have this or that, you can't, we're not going to rent to you. And it prohibits discrimination in the terms, conditions, or privileges pertaining to the rental or lease of any house or in the furnishing of facilities or services. So it still requires that the first payment be timely and in accordance with regulations. But in terms, they can't, it also isn't just whether or not a person is able to rent the property, but are the terms of the lease prohibitively harsh on people receiving a specific source of income. So something like all residents who are receiving some sort of housing subsidy or rental assistance are not allowed to use the pool or the communal areas, only other people are. That would be a term of discrimination, even though they're still able to rent the apartment. The landlords cannot say that housing is not available if it is, to circumvent this prohibition. So a landlord can't say, if a landlord knows that someone receives rental assistance, cannot say, oh, all of our units are full, when in fact they have 2 or 3 open units. They cannot advertise that a certain source of income will not be accepted. So they can't say anyone who's received rental assistance we don't accept anyone who receives rental assistance from living in our community. They can't put out a notice that says something to that effect, or have and they cannot for profit induce or attempt to induce another person to rent housing by representations regarding the entry or prospective entry to the neighborhood with a certain type of income. So this provision is preventing landlords or other people from saying, hey, you know, they don't accept people who have rental assistance there. It's, you know, only people over such and such a threshold, which would, or they could say over such and such a threshold, but not differentiate and sort of entice people by having someone else say that this is you know, there's no one on assistance here. There's a couple exemptions to this law. A landlord with 3 or less properties is exempt. And this is like units for rent. So anyone with 4 or more properties for rent would be included in the law. Landlords can still check credit. And the law spells that out explicitly, that a credit check is not source of income discrimination, and they can have minimum credit thresholds. All of that is legal. And then it's not explicitly stated, but widely interpreted in other states who have had interpretations on this to mean landlords can verify income and require proof of income. They would just have to include rental assistance or housing subsidies in that calculation as long as the tenant can provide proof of it. So in terms of a voucher, if they're able to use the voucher at that property, they can say, you know, this is, I make X amount of money from my job or a fixed income or whatever, and I have this much in a housing voucher that covers this much. That would be their total income that the landlord would be required to consider. And then as long as it is in accordance with all the other laws, a landlord with 5 or less single family rental homes and no more than 5 total rental units, including the single family rental homes, is not required to accept housing choice vouchers for any of those 5 single family rental homes. This was an amendment that I believe was proposed by the Colorado Realtors Association in the legislative history, and it was adopted as such, so that if people are renting out sort of single family properties and they don't have more than 5, or if they have, you know, a building with 4 units and then 1 single family property, they would also be exempted. And this just applies to the housing choice vouchers. It doesn't apply to other rental assistance. So the legislative history of source of income in Colorado, it passed during the COVID-19 pandemic alongside the creation of the emergency rental assistance program, and became effective on January 1st, 2021. There were relatively low levels of testimony in committees, and most of the proposed amendments were adopted, which is where the language about the credit checks and some of those exemptions, that's where they come from, is listening to the feedback. And support came from tenant advocates, entities such as the Good Business Colorado, Denver Housing Authority, health-based groups, and there was relatively low pushback. Most comments were either in favor of amendment, or something along the lines of, right now we can't support this bill, but with the inclusion of certain amendments, we would be more agreeable to it. And then I think one offhanded comment of that this was not a good idea, and that this would prevent landlords from accepting rent. And so, like I said, there's no current case law in Colorado, so the interpretation of this law is still pretty open. And when I say no case law, I'm talking about going through the judicial process. My guess would be Kelly at Dora with the CCRD may have seen some may have seen the occasional source of income discrimination raised and may have some insight into how these cases are proceeding. But in terms of court decisions, there haven't been any yet that I'm aware of. So then just some statistics and looking at other states. So this map is from the multifamily, I'm totally National Multifamily something council. I'm totally blanking on their name. They are an industry group that was tracking source of income discrimination laws, and this is sort of the key that they've come up with. So Colorado's in the mix with Washington, California, Iowa, Illinois, New York, Maine, Massachusetts, Rhode Island, Delaware, and Maryland, and I believe also DC, in having, well, DC wouldn't have statewide, but having both statewide and local ordinances in effect. And then Oregon, North Dakota, Utah, Virginia, Vermont, Connecticut, New Jersey, and then DC have with statewide or district-wide source of income. So it's sort of a mix. It's not all red states or all blue states, which is somewhat interesting in housing law. That doesn't happen all that often. And then you can see there's some other variations where there's no statewide or local effects. There's statewide excludes Section 8 housing vouchers. Statewide law excludes Section 8 vouchers, but local ordinances may differ. That there's a state preemption on source of income laws, but local ordinances may differ, or there's just nothing said one way or another. So I found that to be interesting. I hope you did as well. And then I also found these statistics. These were used to pass. This was a regional study of 6,000 tenants, and it showed that 39% of Section 8 voucher holders reported experiencing discrimination for any reason, compared to just 15% of overall renters, and that Section 8 voucher holders experienced displacement at nearly double the rate of overall renters. And so while this can't be tied down specifically to source of income, it does create a sort of the nexus for the displacement or for the discrimination. It does sort of tie together. It at least shows sort of a correlation that people specifically receiving Section 8 vouchers are experiencing displacement and discrimination at higher rates than others. And I think in that same study, it came out that about 10% of people said that they experienced specifically source of income discrimination. And so discrimination law is always sort of difficult to pin down, because we're talking about, especially with source of income, because we're talking about amount of income and source of income, and trying to differentiate those two. And sometimes it's really, really clear, and sometimes it's really, really blurry and muddy. And so as cases go through Colorado, I'm sure we'll get some more insight into how Colorado specifically is interpreting the difference. But it probably will be a pretty slow case-by-case process to see that. And then quickly, I just wanted to touch on the Denver prohibition on source of income discrimination. So this has been around a little bit longer, since January of 2019. And that's the citation, the Denver Revised Municipal Code, starting in Section 2891 and moving forward from there. It added source of income as a protected class and prohibits discrimination based on source of income in real estate transactions, certain banking practices, and rental agreements. It's really focused on the rental agreements. But that's just sort of how the ordinance is laid out at a more general level. It does not apply to multifamily dwellings with 2 or fewer units, not unites, where the other occupant is the owner. So even if, say, there's a carriage house situation, something like that, in such a small landlord-tenant situation, source of income discrimination does not apply in those situations. And it does not apply to group homes, self-care elderly homes, self-care homes, or other facilities whose use is restricted to elderly or individuals with disabilities. This, I believe, was to accommodate, sometimes places like that also discriminate, not discriminate in a negative way, but are only available to people making a certain income or only qualify under certain grants and things like that. And so I believe that was exempted to allow for sort of ongoing practices of allowing certain individuals to continue to use facilities. There's a special enforcement process, which is different from the rest of of Denver's Anti-Discrimination Act or code, that people can submit a complaint to the Denver Anti-Discrimination Office, which then investigates. They can mediate and they can issue a decision that includes some fines and penalties. And Kelly from the CCID can correct me on this if I'm wrong, but I think this is slightly different in that to file a lawsuit, including asking for an injunction, which would be asking the court to do something like stop evictions based on impermissible source of income discrimination, that to use the Denver ordinance, complainants must go through the administrative process first, whereas at the state level, people could file a complaint with the CCRD, or they could go directly to a court to ask for an injunction to stop the discrimination, essentially. But the complainant must bring the claim within 180 days of the violation, and the investigation is supposed to be completed within 60 days. So that's a little bit about the Denver prohibition. And these are some of these situations come from case law in other states or jurisdictions that have this, or from cases that I've researched. So a landlord refuses to renew leases for all tenants who used emergency rental assistance to pay rent within the last year, but the tenants otherwise meet the qualifications for a lease renewal. So if someone, say, was laid off for a period, paid their rent with with the rental assistance, and then is now employed again and meets the income threshold, that using the emergency rental assistance for a short time would be considered source of income discrimination. Requiring additional security deposits from tenants who have utilized rental assistance. This is sort of up in the air. There's not a case directly on point. I just think this is an interesting question of if someone, and there's no other difference in their case than other tenants, but in the last year used some form of rental assistance, requiring them to pay additional security deposits if they otherwise meet all the requirements. If that would be source of income discrimination, it could be. Prohibiting people using rental assistance or a housing voucher from accessing amenities such as a community pool or lounge area. Unfortunately, this is something that occasionally comes up where not necessarily the landlord as like the legal entity as the head, but someone on the property management team might make a disparaging comment against people receiving rental assistance, and might say you know, you're not paying your own rent, you don't deserve these luxuries or something to that effect. And that occasionally people say things like that. And this raises a specific point that there has to be an outcome that's bad. It can't just be a general dislike of people based on source of income. It would need to be that that's followed through with some actions, which makes this law which may make this law sometimes more difficult to enforce. And then finally, issuing a notice to quit to all month-to-month tenants who use rental assistance to pay rent. That would be, as long as it's premised on using the rental assistance as opposed to falling below a certain income, and if they're able to document and calculate the income, that would be source of income discrimination. So that takes me through the end of the slides. Here's some more, these are some links to things I talked about today, the state bill, the Denver ordinance, our website, and then I also included fixmyrental.com. We didn't touch on the warranty of habitability today, and living in habitable conditions, but if an apartment is not in habitable conditions, Fix My Rental is a pretty good resource to figure out whether that's legal, illegal, potentially on the fence, something in that realm. And then this is my contact information. Please feel free to reach out with questions or follow up, anything like that. And with that, I'll go back to the questions. It looks like there's some in the chat or on the Q&A. So the first one, I find that landlords often try to get around source of income discrimination laws by requiring that someone has 3 times rent, like you mentioned. Is there any way at all for tenants to advocate for themselves to push back against this? Yes, there's a number of different ways. They're not always very successful. One thing is to track these issues to see if it's happening, to try and work with other tenants in a building to see if everyone is being treated the same. So discrimination laws sort of operate on two different wavelengths. One is showing that something happened to an individual that was discriminatory, and then one is tracking the issue at more of a systemic level and saying that this has happened to substantially all tenants that have the same characteristic. And so if we're able to say, like, you know, this one apartment building, they told all of the tenants with a voucher that they had to have 3 times the required income, but then they told all the tenants without a voucher that they only had to have 2 times the income, then there's a disparity there that's illegal. Excuse me. There's also, in a situation like that, there's other things that tenants have done. Some tenants have formed like tenants organizations where they collectively ask for better treatment. So that would be more likely in a lease renewal situation than in an application situation. But I agree that's a big problem. Requiring 3 times the rental assistance or the amount of rent is pretty tough, especially in areas where rent is going up so substantially over the last couple of years. Can you please clarify the 3 or less property exemption? Is this available units at the time or total units? Total units. So this exemption was to allow sort of mom and pop landlords a little bit of breathing room. So 3 or, yeah, if they have 4 or more, then they're subject to the law. What is the reasoning behind having source of income discrimination laws apply only to landlords with 4 or more rentals? This is sort of a common theme within the legislative process, where a lot of they often refer to themselves as mom and pop landlords, have less access to resources like legal counsel, things like that, and they may very well be trying to be compliant with source of income and all of that stuff, but to ensure that they are and to limit their liability would be in some way prohibitively expensive. It's usually a provision that gets added at some point during the committee hearings. For some reference, only 1.6% of tenants going through evictions have legal representation, whereas 76% of landlords do. And so there's that big power imbalance, but then small landlords who are oftentimes potentially more fair to tenants generally may have more, and that's my opinion, that is not statistically proven whatsoever that small landlords are better to their tenants. That's generally there's more of a relationship there is what I'm basing that on. That's not to say anything against anyone else, but yeah, it's more to protect that sort of small person from prohibitive overhead and those kinds of costs. I wish there was a training that voucher holders could take to help them know how to talk about their vouchers to landlords. Yes, I think that's really an important thing to do. We do know your rights trainings to a variety of different folks, and could potentially set up something like that if that's something you're interested in and something you're able to do based on your position in the government. Happy to help with that, or to provide information on other Know Your Rights trainings that are happening that voucher holders could attend. When someone with a voucher is applying online for a unit, how would they demonstrate their voucher as a source of income? Would they just be able to provide the landlord with a copy of their voucher plus verification of any other income that they have, or would the landlord require more than just a copy of the voucher? This is another thing that sort of falls under the yet to be decided, because we don't have a lot of case law on this yet. I would think that providing a copy of the voucher and potentially any sort of in a statement that says this is how this works would be verification of the source of income. And I would think that a landlord would be required to honor that. And if they didn't, that would potentially be a violation that we could move forward with. But like I said, there's not case law on this yet to know, to give you a clear yes or no answer on is that enough and what would be enough. Potentially having a statement on how vouchers work along with the copy of the voucher might work. It's sort of, I know that's not a very satisfying answer, but that would be something that would be decided by case law. In my opinion, I would think it should work, but that doesn't make it the law of the land. In my experience, source of income protections seem to be pretty useless. If a landlord doesn't want to rent to people with vouchers, all they have to do is say, sorry, we need to see 2.5 to 3 times the rent in income, even when they know full well that nobody or virtually nobody with a voucher would have that level of income, because if they did, they wouldn't qualify for the voucher in the first place. Or they insist on a cosigner, and I'm sure there are other examples. They can so easily get around source of income protection. It's very frustrating. Do we need just to wait until case law addresses these holes, or is there any talk in the legislature to add more teeth? I agree that this is really frustrating, that there's ways to get around it, and it's hard to track and it's hard to enforce. So I think this is there any current legislation to add more teeth? I don't think there's any current legislation. That could potentially be an issue that tenants want to organize around. And if that's the case, then I think there are some more teeth to give the law. Otherwise, I think it really is a wait until some of these cases come to the courts and see what happens, which I know is also a frustrating answer to a frustrating situation. There's sort of tangential ways to impact this, such as some of the potentially like the affordable housing laws or other housing laws that potentially could impact that. A lot of what we're seeing in Colorado is that there's still the prohibition on affordable housing. And so there's some, or not on affordable housing, on rent control. And so sometimes if a provision that specifically targets that like 2 to 3 times income level or some of those rules get swept up into the this is rent control by another name arguments. And so sometimes that's how stuff ends up the way it does. But I also share your frustration, and I am sorry that that's how we're seeing this play out, and hopefully between case law and some policy amendments, hopefully that can have a little more teeth to it. Are there any other questions? Well, with that, thank you all so much for having me and for letting me present. Please follow up with any questions or other training ideas. We're happy to continue these conversations. And with that, I know Kelly from Dora is not feeling super great, but if you want to have a couple of minutes, I know that was originally the plan, so I will turn it back over.
Thank you so much, Kelly.
Absolutely.
Yes, thank you, Kelly and Kelly, both. This was awesome, and I do look forward to getting your slides, Kelly, that we can share with our mailing list, because I think that's really helpful and provides muddy clarity to a lot of things, but a lot more clarity than I certainly had. So that's great. Yeah, it doesn't look like we have any other questions. We did get a flyer from the Colorado Civil Rights Division that we'll share out with the slides to everyone on this call or everyone on my mailing list. So we'll have some resources, but yeah, with that, I think that's good. This might be one of our longest webinars yet, and that's good. This is a lot of good information to fill that time. All right, thank you, everyone. We will see you all next month when we have our April webinar topic to be determined. Thanks all. Have a great day.